All right, ladies and gentlemen, welcome back. Today we're going to be going over two statutes within the Uniform Commercial Code that are quite literally the holy grail of discharge. We're going to be going over the uniform laws annotated, some of the comments within. We're going to be touching on a little bit on Restatement of Contracts. We're going to touch on House Joint Resolution 192, just a little bit. Sections 3-311 and 3-603 of the Uniform Commercial Code. Also going to be touching on 31 U.S.C. and 31 C.F.R. For a few little definitions to assist us in our understanding. So, with that being said, let's go ahead and start out here at 3-311. Accord and satisfaction by use of instrument. So we have here, if a person against whom a claim is asserted. So let's just stop right here. Who is the person against who a claim is asserted? Well, if a draft is being drawn on you, aka you are being sent a bill, that is a claim that is being asserted against you, because that person is ordering a payment to be made by you. Okay? So, if a person against whom a claim is asserted proves that 1. The person in good faith tendered an instrument to the claimant as a full satisfaction of the claim. Now, this is very important. This is a very important aspect. The tender needs to be in good faith. Okay? It cannot be fraudulent by any means. It cannot be intended to defeat the rights of the claimant. Okay? It needs to be in good faith. Very simple. We can actually even go in here and see what the U.C.C. defines good faith as. Good faith means honesty in fact and the observance of reasonable commercial standards and fair dealing. So it has to be done under a fair dealing. Okay? That is the very first requirement. The second requirement is the amount of the claim was unliquidated or subject to a bona fide dispute. What that simply means is if the claim is unliquidated, that means it's just simply not paid. Okay? So the claim is outstanding. We have an open account. The account is not liquidated. It is not zeroed out. The account is not balanced, so therefore it is subject to a bona fide dispute because there is an unbalanced account in question. Okay, that is unliquidated. So that's very easy. That's the second requirement. And the third requirement is the claimant obtain payment of the instrument. Very simply, and we'll touch on this as well once we dip into the comments over here. Then we have subsection B. Unless subsection C applies, the claim is discharged if the person who asserted the claim proves that the instrument or accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. Put very simply, the claimant needs to have knowledge that the instrument is being tendered as full satisfaction of that claim. Okay? And then we have subsection C here, which just discusses reasons why it would not be discharged. And that is simply if the claimant proves that within a reasonable time before the tender, the claimant sent a conspicuous statement to the person against who the claim is asserted, the person that's paying it, the communications concerning disputed debts, including an instrument tendered in full satisfaction of the debt, are to be sent to a designated person, office, or place, and the instrument accompanying the communication was not received by that designated person, office, or place. So unless the person that's making the payment is under a notice by the claimant that is supposed to be sent to a particular place and it wasn't sent to that particular place, obviously it's not going to be discharged. Okay, and number 2, the claimant, whether or not an organization proves that within 90 days after the payment of the instrument, the claimant tendered repayment of the amount of the instrument to the person against who the claim is asserted. This paragraph does not apply if the claimant is an organization that sent a statement complying with paragraph 1I. Okay, so this is essentially if the claimant comes back and returns that instrument or returns an instrument of equal value, okay, within 90 days after payment of the instrument. All right, simple as that. And we have subsection D. A claim is discharged if the person against who the claim is asserted proves that within a reasonable time before collection of the instrument was initiated, the claimant or an agent of the claimant having direct responsibility with respect to disputed obligation knew that the instrument was tendered in full satisfaction of the claim. Okay, so 3-311, very, very important. Accord and satisfaction by use of instrument. If we have an open account, we use an instrument, and we state, we're tendering this instrument as full satisfaction of the claim, and we make that conspicuous, and that instrument is delivered to the claimant obtains that payment, then we have discharge of the claim. We have discharge of that bill. Okay, so let's go ahead and touch on what it says here in the editor's notes. This is Uniform Laws Annotated, Uniform Commercial Code, Section 3-311. I highlighted certain areas that I wanted to touch on. The person against whom the claim is asserted may attempt an accord and satisfaction of the disputed claim by tendering a check to the claimant for some amount less than the full amount claimed by the claimant. A statement will be included on the check or in a communication accompanying the check to the effect the check is offered as full payment or full satisfaction of the claim. Frequently, there is also a statement to the effect that obtaining payment of the check is an agreement by the claimant to a settlement of the dispute for the amount tendered. Okay, this is critical to understand, because if we have a claimant who is presenting us with a bill, and our bill states that the amount owed is $10,357, and we come in and we tender a check or any other type of negotiable instrument that states either on a check or in a accompanying communication to the check that the check is offered as full payment or satisfaction of the claim, and the claimant receives that, and the claimant is in notice of that, and continues to deposit that check or further negotiate that check, the claim is completely discharged. This is what Section 3-311 is telling us. And these Uniform Laws Annotated, the comment sections in here are absolutely excellent as well for understanding this in detail. Okay, and the next thing that I wanted to showcase here, Section 281 of the Restatement of Contracts, which states, in promises for an agreed exchange, a promisor is discharged from the duty of performing his promise if substantial performance of the return promise is impossible because of the non-existence, destruction, or impairment of the requisite subject matter or means of performance, provided that the promisor has not himself wrongfully caused the impossibility or has not assumed the duty that the subject matter or means of performance shall exist unimpaired. Okay, so this is very important. Okay, you have to understand that here we have House Joint Resolution 192, okay, which states that every provision contained in a maiden obligation purports to give the obligee a right to require payment in gold or a particular kind of coin or currency or in any amount of money of the United States measured thereby is declared to be against public policy. Okay, so if you're receiving a bill that has United States dollars on it, well, guess what? You can't make payment on that. That's against public policy. Okay, it's against public policy to make that payment in United States dollars. You see? Okay, every obligation hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any coin or currency which at the time is legal tender for public and private debts. And this is where we start to come to legal tender laws. Okay, 31 U.S. Code 5103, United States currency are legal tender for all debts, public charges, taxes, and dues. All right, well, what is currency? What is United States currency? The paper money of the United States that is designated as legal tender and that circulates and is customarily used and accepted as a medium of exchange in the country of issuance. Okay, customarily used and accepted as a medium of exchange. Customarily. What are customs? The customs of banking, the customs of merchant law. Okay? It's codified within the Lex Mercatoria, bills of exchange, promissory notes, bonds. We have all of these things. You can read the Lex Mercatoria. You can read the Merchant's Companion. You can read the Merchant's Directory. And guess what? It talks about all of this. It discusses bills of exchange. It discusses promissory notes. It discusses bonds. It discusses the entire system that's being utilized today. Okay? And clearly, obviously, drafts, bills of exchange, promissory notes, these are all customarily used and accepted as mediums of exchange in the country of issuance. We're still utilizing bills of exchange. We're still utilizing promissory notes in the United States. So yes, that would mean that bills of exchange, checks, promissory notes, these are all currency, okay? And this is 31 C.F.R. section 1010.100. So United States currency are legal tender for all debts, public charges, and taxes. So with that being said, let's move to monetary instruments, because this is another key that I want to touch on here as well. This is also 31 CFR section 1010.100, subsection DD here. Monetary instruments. Monetary instruments include currency, traveler's checks in any form. All negotiable instruments. All negotiable instruments, okay? And this includes personal checks, business checks, official bank checks, cashier's checks, third-party checks, and promissory notes, as that term is defined in Uniform Commercial Code, and money orders that are either in bearer form, endorsed without restriction, made to a fictitious payee, or otherwise in such form that title thereto passes upon delivery. And then we also have incomplete instruments, securities or stocks, yada, yada, yada. And also monetary instruments do not include warehouse receipts or bills of lading. Okay, so coming back to, yes, the restatement of contracts. Well, it's impossible for us to make a payment in a particular coin or currency, okay? So this is the inability of one party caused by destruction of the subject matter, okay? Very simple. Now, moving back, comment 3 here says, Section 3-311 governs full satisfaction of checks, all right? Subsection A states that 3 requirements for an application of subsection 3-311, good faith in subsection 3-103A6, as not only honesty in fact, but the observance of reasonable commercial standards and fair dealing. Okay? Section 3-311 does not apply in cases in which the debt is a liquidated amount and is not subject to a bona fide dispute. For purposes of subsection A3, obtaining acceptance of a check is considered to be obtaining payment of the check. The person seeking the accorded satisfaction must prove that the requirements of subsection A are met. Okay? They must prove it. And the way that they prove it is through their documentation. They're documenting the entire process through having certificates of service, through having everything that they need, sending it through certified registered mail, however it's sent. This is all form. This is all evidence that proves. Okay? This is all evidence that proves. Very simply. Okay? Subsection B requires a conspicuous statement that the instrument was tendered in full satisfaction of the claim. So it needs to be a conspicuous statement. All right, we can't write it in 7-point font, 5-point font, and try to hide it. We can't try to hide that provision. We have to make sure that it's a conspicuous statement, that they are clearly, that there is no doubt that the claimant is aware of the statement. Okay, simple as that. A statement is conspicuous if it is so written that a reasonable person against whom it is to operate ought to have noticed it. Okay? Very simple. Very, very simple. Okay? And I believe that that's it. A claimant knows that a check was tendered in full satisfaction of the claim when the claimant has actual knowledge of that fact. And then this discusses notice over in section 1-201 of the Uniform Commercial Code. You should obviously know everything that you see in Article 1 of the Uniform Commercial Code. You should know that one, okay? Whether or not you're operating in that or not. And another thing that I want to say with regards to that is that the Uniform Commercial Code, while it does discuss and break down these certain things, in the different articles, it really all is talking about one thing, okay? And once you get to the point where you understand that, then you'll know what I'm talking about, okay? It's not really discussing all these different things. While it is doing that, it also serves as a guide for one thing, okay? And you'll understand that one thing as you continue with your studies, okay? So, put very simply, the person needs to have conspicuous notice. Very simple. If they don't, it shouldn't be any type of, I'm trying to get around it, trying to do anything like that, because that's not good faith to begin with. With respect to an attempted accord and satisfaction, the individual conducting that transaction is an employee or other agent of the organization having direct responsibility with respect to dispute. So, If the check and communication are received by a collecting agency acting for the claimant to collect the disputed claim, obtaining payment of the check will result in accord and satisfaction, even if the claimant gave notice pursuant to Section C.1 that the full satisfaction checks be sent to some other office. That's another very important thing that I wanted to highlight there. And last thing is, if full satisfaction of a check is sent to a lockbox or other office processing checks sent to the claimant, it is irrelevant whether the clerk processing the check did or did not see the statement that the check was tendered at full satisfaction of the claim. Knowledge of the clerk is not imputed to the organization because the clerk has no responsibility with respect to an accord and satisfaction. Moreover, there is no failure of due diligence under Section 1-201 if the claimant does not require its clerks to look for full satisfaction statements on checks or accompanying communications, nor is there any duty of the claimant to assign that duty to any of its clerks. Section 3-311C is intended to allow a claimant to avoid an inadvertent accord and satisfaction by complying with either subsections C-C1 or 2. Without burdening the check processing operation with extraneous and wasteful additional duties. All right, so that's that. Next one that I want to look at, there's the two that you need to study. You need to study Section 3-311 and Section 3-603. All right, so Section 3-603, tender of payment. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the effective tender is governed by principles of law applicable to tender of payment under a simple contract. You'll be able to understand the principles of law applicable to tender of payment under a simple contract within Article 2 of the Uniform Commercial Code. Okay? If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender of the obligation of an endorser or a combination party having a right of recourse within respect to the obligation to which the tender relates. So if we are tendering payment on an obligation to pay an instrument to a person entitled to enforce that instrument, and that tender is refused, there is discharge to the extent of the amount of the tender, okay, of the obligation of an endorser or a combination party having a right of recourse with respect to the obligation to which the tender relates. And subsection C, if tender of payment of an amount due to an instrument is made to a person entitled to enforce the instrument, the obligation of the obligor to pay interest after the due date of the amount tendered is discharged. Okay, now this is just discussing interest on the obligation. Okay, if presentment is required with respect to an instrument and the obligor is able and ready to pay on the due date at every place of payment stated in the instrument, the obligor is deemed to have made tender of payment on the due date to the person entitled to enforce the instrument. Okay. So when we have tender of payment, okay, when we have tender of payment under Section 3-311 and 3-603, as long as the provisions within both of these statutes, we can check those off, then we have discharge. And that is what I wanted to showcase to you. You need to understand Section 3-311 and 3-603 so that you can understand how to employ these statutes and get yourself a remedy within a court of law. These two, Section 3-311 and Section 3-603, are going to be the most important for you to understand. If you're brand new, this probably is not for you. If you're intermediate, look into it because this can take you to a new level. Section 3-311, Section 3-603. Okay, so that's all for today. Hope you guys enjoyed. Appreciate you tuning in, and we'll talk soon.